Hello and welcome to the Why Should I Care Civil Procedure podcast. I'm your host, Alexandra Lahav, and today we have a very special guest, Professor Diego Zambrano, who's a professor at Stanford Law School. So, Professor Zambrano, why should we care about subject matter jurisdiction?
Hi, Alexi. Great to be here. Let me start by, defining what I mean by subject matter jurisdiction. And this is really the set of doctrines and constitutional principles that govern access to the federal courts. And by consequence, what cases remain in state court instead. Right? So your students are going to learn about personal jurisdiction, and that determines the power of the court over the parties, the litigants. But subject matter jurisdiction governs the court's power over the substance of the case. And the starting premise is that under Article 3 of the Constitution, federal courts are courts of limited jurisdiction. They're authorized only to hear certain cases that deal with federal questions, statutes, or parties from different states, what we call diversity jurisdiction. So, subject matter jurisdiction is fundamentally a question about the authority of the federal courts to adjudicate a certain case, right? So, with that understanding, why should we care, right? Why is this so important? Well, let me start from kind of a top view. That is, that if you're a student of American law and institutions, you really ought to care about subject matter jurisdiction because it determines the distribution of judicial power between the state courts and the federal courts. It's at the heart of what we call judicial federalism in the American legal system. So it determines access to court, coherence of federal and state law, the shape of procedural law in both systems, and most importantly, it determines which judiciary of these two systems that we have has the power to set policy questions that affect lives, liberty, consumers, families, corporations, etc. There's actually a really long and fascinating history about how subject matter jurisdiction and access to the federal courts has helped parties escape provincial and local biases, sometimes of the state courts. So let me just give you a few examples. One of the great contributions of the Civil Rights Act of 1964 was not only its substantive provisions, but the fact that it gave civil rights activists a federal forum. They were able to take their case in front of a federal judge that looked very different than state court judges, especially in the South, right? This was an escape hatchet. It was a powerful tool where you could escape biased state court systems. Now, that was true after the Civil War as well. In 1875, Congress adopted the first plenary federal question jurisdiction statute. And one of the motivations was to give newly freed slaves access to federal courts, and again, an escape from state courts. This was even true, you could say, after the American Revolution, right? The framers wanted diversity jurisdiction partly so that parties could avoid state court biases. Now, you could also care about this from the other side of the spectrum, right? You could care about subject matter jurisdiction because you want to make sure you don't end up in federal court, right? Because you think that you're going to get a better or fairer shake in state courts. And there's a lot of historical circumstances where that has happened, right? In the early 1900s, during the Lochner era, progressives felt that state courts were much friendlier to labor claims than conservative pro business federal courts. So diversity jurisdiction, right? This jurisdiction that governs claims between parties from different states. Progressives really wanted to eliminate it. They wanted to shrink it so that more cases would be funneled to the state court systems. And one of the most famous justices of all time, Justice Frankfurter, attacked diversity jurisdiction for decades, once calling it the mischief inflicted on the federal judicial system. Fast forward to the 1990s, you actually have the same kind of debate happening. And that is consumers and plaintiffs' attorneys feel like state courts are giving them better access, all right? More likely to get a class action certified, while in federal court, those claims are likelier to be dismissed. Pro business groups see this as a problem. They start criticizing state courts as being too friendly to these claims, as being too lenient on plaintiffs' attorneys. So what do they advocate? They advocate for changes to subject matter jurisdiction, to federal courts, right? This heated dispute between plaintiffs' attorneys, consumer groups, labor groups, and businesses on the other side all gets resolved through a subject matter jurisdiction statute, the Class Action Fairness Act of 2005. The entire statute, all that it does is mostly change the jurisdiction of the federal courts to hear large class action cases. So all of these examples get to the same point, which is that subject matter jurisdiction is extremely important. It completely determines which court system will settle these massive policy questions. Right, so that's kind of a high level academic reason to care. Another reason to care, though, from a more lawyerly angle, right? As a future lawyer, why should you think that this doctrine is important? That's because picking which court system you're going to file in is a profoundly strategic choice that has a significant impact on the entire trajectory of the case, right? If you go to one system or the other, that can completely change the outcome. We have a long literature in civil procedure on choice of forum clauses, on the differences between state and federal courts, on the difference between arbitration and litigation. All of those literatures and research find that forum matters. So if you're a lawyer and you have to decide where your client is going to be litigating, if you're on the plaintiff side, if you're on the defense side, you have to decide whether to remove a case filed in state court to federal court. Uh, you have to make this decision, and you have to do it strategically. Right? Now, I should say this is kind of unsavory to a lot of people. There's a pejorative name for this, which is forum shopping. But if you're a lawyer, you have the duty of zealously representing your client, and that means you have to pick the forum that's going to most likely benefit your client, right? The forum that will be best. Um, let's say a third reason that's related to the second one is that subject matter jurisdiction defects are not waivable. So everything you learn in personal jurisdiction, ultimately, the parties could just completely ignore it. The parties can show up in the court and say, we don't care about personal jurisdiction, we're going to litigate here. And the court would hear the case. That's not true for subject matter jurisdiction. Because it is a limit on the sovereign power of the federal government to host certain cases, you cannot waive it. It doesn't matter what the parties want. The court has to make sure it has it. And so there have actually been a lot of examples of litigants that have gone 8, 10, 12 years litigating in federal courts. And all of a sudden, a subject matter jurisdiction defect appears that was evident there that was there hidden the whole time. And the case gets dismissed. You actually have to go back to state court and start from scratch. 10 years wasted. So if you're a lawyer, you want to make sure that the court has subject matter jurisdiction. Right? You don't want to be stuck in such a situation. Now, I think we could have a really interesting conversation, but I'll pause there on the differences between state and federal courts. Like, what are the factors that you need to think about when you make that choice?
Yeah, so there are two things I want to follow up on. One is, what do you think are the differences? And I'd like to poke you a little bit and say that a lot of federal judges actually come from the state judiciary originally.
Yeah.
And so is there really such a difference? That's one question. But I have another question too that I want to get to after that, and to preview for our listeners, which is, let's talk about the relationship between subject matter and personal jurisdiction. I think it can be
Yeah.
confusing to people, and so I want to flesh that out also. But let's start with, are they really that different?
Yeah. So let's talk about all the potential differences, and we'll get into this idea that are you really going to get different kinds of judges, right? So when I teach this class, or more like 4 or 5 classes on subject matter jurisdiction, we start off with this discussion, right? What are these potential differences? One is juror characteristics. When you go to state court, the jury pool is mostly determined by the people living in a state county. If you go to federal court, the pool is going to be determined by people living in the entire federal district. Those two geographies don't correspond with each other. So you could end up with a jury pool in the federal district that's much more urban, right? That includes a major city, more diverse crowd, different interests. different kinds of companies in that district. If you go to the state court in the same area, maybe the county doesn't envelop that city. You might end up with a more rural county or a more rural jury pool, different kinds of interests, less commercial, etc. So that could really affect the outcome of the case if you're thinking you're going to go to a jury trial. There are also different jury verdict rules. There was a Supreme Court case this year on jury verdict rules in the criminal context. But in the civil context, you can still have different rules at the state level. And California, for example, doesn't require unanimous jury verdicts. That's not true for the federal system. So you want to think about all those little differences that can actually have a big impact on the ultimate decision. Okay, so setting aside the jurors, the other major difference that usually gets discussed here is judges, right? And let's start off with kind of the basic difference, right? Which is different methods of appointment. Most states still retain some form of judicial elections, right? I think it's something like 37 states have some form of judicial elections. Uh, Either way, it's going to be a complete different process. At the federal level, every federal judge is nominated by the president and confirmed by the Senate, right? At the state court level, you might have some appointments, you might have some elections, you might have gubernatorial appointments, commission appointments. So you might be selecting for very different kinds of people here, in theory, right? You're selecting for not only different judicial characteristics, but different political incentives, different biases, different legal cultures, norms, practices. Judges hang out with different crowds, the ones that end up at the federal district court than the ones that end up at the state court level. And they're influenced by those crowds, and that can affect how they decide cases, right? For example, you might imagine that an elected state judge may have a political incentive to protect local companies, right? Or to protect local interests of one kind or the other. Maybe elected state judges have different sympathies for different kinds of parties. Does that mean they're biased? Not necessarily, but it's a concrete difference between the structural incentives of state and federal judges. If you have a federal question case, you could file it in state court and litigate it in state court unless it gets removed, right? But you may want to go to federal court because the federal judge is seen as more of an expert, right? Is going to interpret federal law in line with other federal district court judges, right? So there's some uniformity that you get there. That might not be true at the state court level. So you mentioned a really fascinating point, which is that a lot of federal court judges come from the state courts. We've actually seen that in the last few years, a lot of appointments coming from the state court level. So why would they be different, right? Well, as I mentioned, different political incentives, but also I want to restate this point about hanging out with different crowds, right? Even if you come from a state court and you have a very similar disposition and set of values and norms as other state court judges, you're now going to be going to different kinds of events. You're going to be going to different kinds of meetings with federal judges. You might get inculcated into federal way of thinking about the law that is different than the state way of thinking. You're a state judge, you're meeting with state legislators. Maybe you're going to appropriations hearings at the state court level every year, perhaps. You're not doing that anymore if you're at the federal court level. So I think there's a sense in which the culture is different, and that can also affect how judges think about different cases, even if they have a very similar background.
So I just want to interrupt you for a minute and
Yeah.
add that I've heard from federal judges that actually when you get appointed, you go to something they call baby judge school,
Right, yeah.
where this process happens, where you're trained about how to be a federal judge. So I think there's a lot to what you say. One thing you didn't mention that I wonder what you think about is the different procedures that you're going to get in state and federal court. So you pointed out different juries, which in the different jury pools, which I think is really important. But let me just give you an interesting example from my home state of Connecticut.
Mhm.
In Connecticut, when you file a case, you get assigned to a judge. But every time you come back to court, you can get a different judge by lottery in your same case. So you
Wow.
could find yourself having your motion to dismiss heard by one judge, but your summary judgment motion heard by another judge.
Right.
And I've
Wow.
been told by some local judges that this creates an incentive amongst the judges not to grant summary judgment motions,
Right.
because it's a lot of work to grant a summary judgment motion and a lot less work to kick the can down the road to the next judge, right?
Yeah.
Who's going to hear the trial.
Right.
I don't know if that's true, but that's what they say. That's really different than having one judge who's going to follow your case throughout the life of the case and really get to know it. So I'm just using that as an example of a procedure that's very, very different in state and federal court
Yeah.
that might affect your decision making when you're deciding where to file.
That's fascinating, and that's totally right. Which is that you're going to have not only different kinds of procedures with regards to judicial administration, but you're going to have different rules of civil procedure, right? And that's what you're learning in this
Right.
class. And so when the federal rules were adopted in 1938, there was this hope that the states would converge, would adopt very similar procedures, and we would have somewhat of national uniformity over time. Right? And that was true for decades. Most state courts generally tried to approximate the federal rules of civil procedure. But I think a lot of scholars have noticed that in the last 30 years or so, there's been an increasing divergence between the two systems. While federal courts have made changes to pleading standards, class action certification, personal jurisdiction, etc., we really haven't seen the same kind of move at the state court level. At least most state courts, a lot of state courts have. So it may be that there's a systematic difference here now, where if you go to the state court, maybe you have lower pleading standards. Twombly and Iqbal don't apply. Maybe you have easier class certification rules, right? And that will have a significant impact on the outcome of the case, right? If you're representing plaintiffs in a consumer case, maybe you want to file in state court rather than federal court. So that should really impact where you file a case. Now, remember that if you have a case that involves a federal question, you may file it in state court, but it's going to get removed if the defendants want to be in federal court. But you have the chance, if you're a lawyer, to design the case in such a way that maybe you don't file that federal question, maybe you only file it under state law. Now, there are doctrines that try to avoid this. We don't have to get into that. But the point stands, which is that the rules of civil procedure might be very different in state and federal court, and that can affect the outcome of the case. And it's not only that. I mean, we could talk about different rules of evidence. We could talk about the idea of familiarity with the state law at the state level, the federal law at the federal level. We could talk about choice of law rules, which might be different as well. Maybe, and you started getting into how the dockets are managed in Connecticut. Maybe you have a state court docket that is crowded, and your case might take 10 years if it's litigated there. But if you file it in a federal court docket in the same geography, maybe you're going to have a much faster case, right? So there are a lot of other considerations like that that are present here. You mentioned
Yeah.
personal jurisdiction too. I'm happy to talk about that.
Yeah, let's talk about that. I just want to echo your point about time, that the federal courts are proud of the quick resolution of cases. And it's much more diverse among the state courts, how long your case will take. And that obviously makes a big difference to litigants whose recovery is delayed, or who are tied, if you're a defendant, you're tied up in litigation, there may be other issues that you face as a result of that. And so that is, I think, seldom discussed, but very important piece of this. I know you've written about that a little bit in some of your
Yeah.
work. So yeah, let's take a few minutes and talk about the struggles that students have when they're trying to master these doctrines of subject matter jurisdiction, which can get pretty complicated and gnarly. So could you talk a little bit about what you see are the difficulties? I'll tell you one I see is that sometimes it's difficult to distinguish subject matter and personal jurisdiction at first when you're just new to the subject.
Yeah.
I don't know if you see that, and what other difficulties students might have and how we can help them.
Yeah. I mean, let me just start off by saying we make it harder for them by using the concept of general jurisdiction to describe state courts, right? So in the personal jurisdiction, let me back up a little bit. Personal jurisdiction, again, it's about the power of the court over the parties themselves, right? Can you hail this litigant into this court system, right? That is not at all what subject matter jurisdiction is about, which is, does the federal court have the power over this, the substance of this claim? Right? It's a limit on the sovereign power of the federal government. But when we contrast federal courts as courts of limited jurisdiction, we say state courts are not like that. They're courts of general jurisdiction. And we have the same words to describe personal jurisdiction, specific versus general. But those two concepts are very different, right? In the personal jurisdiction context, we just mean that a court can resolve any dispute related to this party, right? All-purpose jurisdiction. We should probably just use that term instead. When we're talking about the state court being one of general jurisdiction, it means it can resolve any substance, any kind of claim. Right? Now, again, those still sound very similar, but the more you get into the weeds of these two different doctrines, you realize how different they are. I think one way to talk to students about this is to ask them to imagine the geography of the United States. Personal jurisdiction deals with a horizontal problem generally. Should you be held to court in California or Florida? Right? Which of these two states have personal jurisdiction? Right? Now, it gets more difficult with a foreign claimant where maybe there's no personal jurisdiction anywhere in the United States. But subject matter jurisdiction is not about a horizontal problem. It's about a vertical problem between the state courts and the federal courts. So I think that's one way to think about the differences. Another way is to remember the concept of waiving it, right? And I think, as I mentioned, you can waive personal jurisdiction, not subject matter jurisdiction. The reason I think it's important is that the reason you cannot waive it is because it's a limit on the power of the federal court. Right? While personal jurisdiction doesn't really get discussed in the same kind of sovereign power terms, it's mostly an individual liberty. Right? It's a liberty of the party not to be held to court in this particular court system. So those are two ways in which I talk about it. Yeah.
Yeah, just to interrupt. So one of the problems I think with personal jurisdiction doctrine is that sometimes some of the cases do invoke this idea of sovereignty.
Yeah.
And it makes it confusing. But I think very similar to what you're suggesting, the way I like to explain it is that personal jurisdiction is about geography.
Yeah.
So what state am I in? And can I sue here? Mm-hmm. Or sometimes I joke with my students about the idea of litigation tourism.
Right.
And I tell them, my dream is to litigate in Hawaii so I can have a vacation there. That's not really true. But this idea of where can I go versus subject matter jurisdiction, which you can be in the same physical locality, the same geography,
right.
But you might end up being in the United States District Court for the District of, I'm going to use Connecticut as an example, or you might end up being in a state court, but you're still litigating in Hartford, right?
Yes.
The place is the same, the courts are different. So that's another way to think about the same problem. But everything you said, I totally agree with. It's just, it can get tricky because of this use of language that seems to apply to both and yet is used in slightly different ways.
And when you're asked to actually go through a question on personal jurisdiction and one on subject matter jurisdiction, I mean, the names might help you there. Personal jurisdiction, what kinds of contacts does this person, this litigant have? Subject matter jurisdiction, what is the substance of the claim? Right? And so those should get you thinking in different ways about these doctrines.
So we only have a few more minutes, and I'm wondering in the last few minutes, what advice do you have to students who are studying this area? And we mentioned a bunch of sub-doctrines. So there's federal question jurisdiction. There's diversity jurisdiction. It has its own set of rules. Then we have the removal statute, which raises another set of rules. The 500-pound gorilla that we didn't mention is supplemental
Right,
jurisdiction.
right. Yeah.
So, do you have any advice to students as they're looking at these sub doctrines within the area of subject matter jurisdiction, um, that things that you think are helpful in thinking through problems?
Yeah, I do think that the different sub doctrines here bring tricky problems. So when you talk about diversity jurisdiction, you have a lot of sub questions. You have amount in controversy, you have the complete diversity requirement, the time of filing rule, the concept of domicile, alienage jurisdiction. The difficulty there is not getting lost in this web of sub questions, right? And I think it's mostly a memorization problem there. So, I tell my students you have to do a lot of the Glannon examples from examples and explanations, right? And I assign that and I ask them do a lot of those exercises. And once you've done a lot of those cases, then all of these start to fit in, right? You start remembering how to apply amount of controversy, how to apply the complete diversity rule. So I think diversity jurisdiction lends itself to learning by doing hypos and exercises. Now, I don't think that's quite as true for federal question jurisdiction because I think it's more of a conceptual problem there. So let me group the cases there into three buckets. I think the easiest cases is when a federal statute creates the cause of action, right? You have a Civil Rights Act claim, you have an APA claim, an antitrust law claim under the Sherman Act or the Clayton Act, and they're pretty straightforward. Second bucket where it starts getting trickier, the well pleaded complaint problems. What if the federal question is not in the well pleaded complaint, but there's a counterclaim that's federal? Or what if there's a declaratory judgment action, right? Those can be trickier. I think the trickiest, where you see a lot of difficulty, is in the third bucket, which is the federal ingredient cases. You have a state law cause of action, but there's a federal question underneath it. Right? And it's unclear whether that federal question is significant enough to turn the whole case into a federal question. So I think my advice here is really have to drill down into all of those cases. Merrill Dow, Grable, Gunn v. Minton, Empire Health Choice. Go through all those cases with a fine-tooth comb, and actually ask yourself, how does the text for the federal ingredient, federal question jurisdiction problem that Grable brings up, how does that test apply in all these four cases? How do all these sub-elements cash out? And do hypotheticals to try to understand that. But that is tricky. You mentioned also the 500-pound gorilla, the question of supplemental jurisdiction, which is significant here. I think my advice there is to print the statute 1367, have it in front of you, and take notes on it, and actually write on it, because you want to learn how the historical cases fit into it, but also how the exceptions apply. Most of the exceptions are going to be to diversity jurisdiction cases, but you want to really, circle Rule 23, Rule 21, the joinder, compulsory joinder. Circle all those exceptions and write out how they apply in a case. And I think that's the only way to go with the supplemental jurisdiction statute.
I couldn't agree more. And I just want to echo something that's so important about what the last thing you just said, which is in general, I find, and I hope you agree with me, that when students are studying procedure, having the rule or the statute in front of you in paper and reading it carefully and circling the key pieces, identifying first, and then circling the key pieces does a ton of work. And obviously, you always have to go back because as lawyers, we can't really trust ourselves to remember exactly what it said.
Yeah.
We always have to go back with our specific example in mind, our client in mind, and look at the rule and think about what our best argument is in favor of our client from the actual rule. But it starts with that engagement that you're describing.
Yeah.
And I can't emphasize that enough for students that you get really far. I've never quite told them to do what you're suggesting. And next time I teach, we're going to do that together, me and my students, because I think it's just the way to go.
Yes.
for teaching these, what is a very complicated and confusing statute that really flummoxes, experienced practitioners and judges, not just those of us who are studying procedure, and those of us who are studying it for the first time.
Yeah, and it's a great exercise in statutory interpretation. So it'll give you a good set of skills. That's certainly true for 1367. I would also recommend it for the diversity jurisdiction statute, 1332. Right? I would go in there and look at all the different subcategories and also write on top of a printed version of it. I think that is really important.
Yeah. So, Professor Zambrano, thank you so much for being with us today. Hopefully, we'll bring you back again. We can talk more deeply about these statutes, but this was really fun, and I really appreciate your insights into this pretty difficult topic. Thank you so much.
It's great to be here. Thanks so much.